Source of Hindu law are the Smritis written by great Sanskrit scholars like Manu, Yagnavalkya, Vishnu, Narad, etc. One of the most prominent of these Smritis is the Manu Smriti and the Yagnavalkya Smriti. As we know, the Hindu law later on got bifurcated into two schools of law, namely Mitakshara and Dayabhag. Mitakshara came to be followed across the country except in Bengal and Assam, where Dayabhag school of law was followed. It is very interesting to understand how these two schools of law came into existence. And the reason behind its coming into existence is the interpretation of one word, that is pind. According to Jimutvahan, who is the father of the Dayabhag school of law, the word pind means the rice cakes offered in the Shraddh ceremony to the ancestors. It is believed that even after the death of a person, his spirit remains for a couple of days, and therefore the Shraddh ceremony is organized wherein the rice cakes, which are known as pind, and water are offered to the spirit. In Manusmriti, it is provided that when a man dies, his inheritance goes to his nearest sapind. So according to Dayabhag, the person who has a right to give this pind to the deceased has the right to inherit his property. So this brings us to the question that who has the right to give the Shraddh? This is provided in the book called Parvana Shraddh, wherein the list is provided as to who can give Shraddh to the deceased. At the top of the list is at serial number 1, the son, who has the right to give Shraddh if his father passes away. At serial number 2 is the son's son, and at serial number 3 is the son's son's son, and so on and so forth. The rule is that if anyone higher in this list is alive, then one does not have to go below the list, and the list terminates there itself. So for example, if the deceased died leaving behind him one or more sons, one does not have to go below that list, and the entire property will be inherited by son if he is the sole son, and will be shared equally by all the sons if there are more than one sons, because only the son has the right to give Shraddh to his father. It is only if the deceased dies leaving behind no son, then one can go lower in the list, and in that case, if the deceased leaves behind his son's son, that is his grandson, then the property will go to his grandson. As per the list, the grandson will have the right to give Shraddh to the deceased. Thus, the Dayabhag school of law has followed the traditional Indian Hindu law approach that a person who has the right to give Shraddh to a deceased has the right to inherit his property. It is for this reason that there is no inheritance at birth in Dayabhag, and there is no concept of copartionary in Dayabhag. So if A dies leaving behind him his son B and B's son C, then according to Dayabhag, C will not inherit his property of his grandfather, because B is alive and B has the right to give Shraddh. In Mitakshara school of law, however, the interpretation of the word pind is different. It does not mean the rice cake which is offered on the death of an ancestor. In Mitakshara, the meaning of word pind is part or particles of the body, and therefore the word sapind would mean the male descendants coming from a common ancestor, and therefore the concept of copartionary is provided in Mitakshara school of law, where up to 3 male descendants, all descendants at birth will get the right of property on the ancestral properties. This is the basic difference between these two schools of law, and this is how, because of the interpretation of the word pind, Hindu law got bifurcated into these two branches.